6 is criminal law. We're going to look at some constitutional protections of suspects. So, the Fourth Amendment protects us from unreasonable searches and seizures. Now, in order to arrest someone or do a search, a cop is going to need probable cause. Now, generally speaking, you're going to need a warrant in order to perform a search or arrest somebody. So, let's talk about this warrant requirement, okay? So, because you're generally going to need a warrant to search somebody, the rule is that anytime you search without a warrant, it's going to be considered invalid for the most part. Now, we have a couple exceptions to that rule. The first is consent. Now, so essentially, if I'm a cop and I search you without a warrant, all right, if I search your house, but I do it because you allowed me to, you consented, then that's fine, okay? That search is going to be permissible. Secondly, exigent circumstances. Exigent circumstances mean that there is something pressing that will not allow me the time to get a warrant, okay? So let's say I'm a cop and I see you about to flush drugs down a toilet, okay? Now, the amount of time it would take me to call a judge and get a warrant and do all that, those drugs will be gone, right? All evidence will be gone. So that would be exigent circumstances. So I can go ahead and do my search right now, even without a warrant, and that search will be okay. And the last one is the search incident to lawful arrest. And that means that if I've arrested you lawfully, right, because of probable cause, that you committed some crime, I can search you at that time, all right? So those three things are times where an officer searching you without a warrant is going to be permissible. All right, Fifth Amendment. Second protection is the right to remain silent, okay? Right to remain silent, obviously it's part of the Miranda rights. You don't have to, testify against yourself in any way. You don't have to talk at all. And this cannot be used by the prosecution in their case, which means that at trial, the prosecution cannot go to the jury and say, hey jury, look, this guy's clearly guilty. He refuses to testify. Only a guilty person would do that. They're not allowed to say that, all right? That's a real quick way to get a mistrial, all right? Third, protection against double jeopardy. So what this means is you cannot be tried for the same crime twice. Civil trials are not included, right? So we're all familiar with, take the O.J. Simpson case, for example. He had a criminal trial, found innocent, and then was sued civilly, right? So two different trials, but one was criminal, one was civil. That's fine. But you cannot be criminally charged for the same crime twice. The Sixth Amendment gives us a few more. First is the right to notice of charges. Now, this is going to aid you in your preparation. So you essentially have to be notified of all the charges against you, right? If you're not properly notified of these charges, how can you possibly defend yourself? 5 is the right to confrontation. This means that you have the right to cross-examine any witness against you, all right? Number 6, you have the right to a speedy trial by a jury. So it has to be relatively quick. You do get the right to a jury trial if you want, and we have a high threshold. We say that the verdict has to be unanimous, all right? We don't want people essentially being put away in jail for 20, 30 years, or obviously, get the death penalty or something like that, for a crime in which, 7 out of the 12 jury members thought they were guilty. That's obviously not fair. If you're going to be found guilty of something, they better be pretty darn sure that you're guilty. So we're going for a unanimous verdict here. And last, of course, is the right to counsel. Now, this begins at interrogation. So the minute you're brought into custody, you can get your lawyer. And this is paid for by the government, right, if you cannot afford an attorney yourself. Okay, so there's a couple other procedural protections that are important to note. The first is the exclusionary rule, okay? What this means is that any evidence illegally obtained by the police is inadmissible at trial, okay? Any evidence that they get illegally cannot be brought into trial. So, we talked about searching without a warrant, and we talked about some exceptions. But let's say there's no exceptions, and the cop just comes into your house, and he finds some drugs, and you didn't consent for him to be there, and there's no arrest, all that. If they take those drugs, that cannot be brought into trial as evidence, okay? There's also something called fruit of the poisonous tree. So what this means is that anything that stems from the illegal search is also going to be inadmissible. So, let's say, for example, the cop comes into your house and he doesn't have a warrant and no consent, all that. Okay, it's an invalid search. let's say he finds a key to a locker, okay? You keep a locker down at the storage unit. He finds a key. He then takes that key to the storage unit, opens up your storage unit, and finds all kinds of illegal stuff, all right? Now, because the search was illegal, therefore him finding the key was illegal, so anything that came after that, right, all the stuff that he found in your locker by using that key is also going to be inadmissible at trial. So the key is not going to be admissible for evidence, and neither is anything he found in the locker as a result of the key. That is the fruit of the poisonous tree. So if the tree is poisonous, then all the fruit that comes from the tree is also going to be poisonous as well. And that's kind of the analogy that they're going for here. And the last one is Miranda warnings, okay? Again, anyone that watches television knows this. You have the right to remain silent. Anything you say can and will be used against you. Right to an attorney, all that stuff, okay? Now, the reason this is so important is because you cannot waive your rights if you haven't been informed of them. So the idea is, if they haven't read you those rights, then there's nothing for you to waive. So therefore, the warning is obviously, the Miranda warnings are necessary because you can't waive what you haven't heard. For anyone that's curious about Miranda warnings and where they came from, there's a case where a guy named Miranda back in Arizona was tried for rape and kidnapping, and he confessed to the crime, but he was not aware of his rights. He was not read his rights. So he was convicted, and the Supreme Court overturned his conviction. So he was retried by the state of Arizona, and this time he was found guilty again. But he was found guilty not using his confession. He was just found guilty on the evidence in the case. So that's why we call them Miranda warnings, or Miranda rights, because they essentially stemmed from this particular case. Miranda himself ended up serving, I think, 10 or 11 years for that conviction, for the second one, the second conviction. He was later released on parole, and he was killed, actually. He was stabbed to death in a barroom brawl not long after. So things did not end too well for Miranda. But that's where the Miranda rights come from.